Greetings, everyone, and thank you so much for joining me at this week's Cloud Title Tip of the Week. And this week, I'm going to talk about probate. We run into this all the time where somebody passes away and their children, daughter, son, relative are selling the home thinking that they are the heirs because there is a will that leaves them the property. And so then it goes on the contract, it comes to the title company, and probate is not opened. In the state of Florida, there are really only two scenarios. Scenario A, where probate is not required, is if the property is owned with another party as joint tenants with right of survivorship. Of course, that other party still has to be alive. And in that scenario, the property just automatically passes on and becomes owned by the other person. There's no need to do anything. There's no need for probate. There's no need to file anything. It is just automatic. When the property is sold, the only thing that we do is file a copy of the death certificate of the person that has passed, and the other person owns that property automatically. If the ownership is as tenants in common, or just an individual owner, then the ownership of that party that passed away has to go through probate. So let's say if Joe and Jeff own a property together as tenants in common and Jeff passes away, then Jeff's interest has to go through probate. The property cannot be sold without probate. And likewise, if somebody owns it individually, it must go through probate. It doesn't matter if the property is a homestead property or not. Probate has to be open. It doesn't matter if there's a will or not. Probate has to be open. So as a real estate professional, if you're ever dealing with a situation where the owner or one of the owners has passed away, take a look at the vesting deed that gave title to the current owners. And if it is not joint tenants with right of survivorship, or in the case of husband and wife, sometimes you may see tenants by the entirety, or just, Jim Smith and Sally Smith, husband and wife, which is always tenants by the entirety, which is joint tenancy with right of survivorship in essence. But if you don't see that, then that needs to be a clue that probate has to be opened. And until a personal representative is appointed, there's no one that can sign on behalf of the estate. So you cannot take a listing. If you take a listing and they're like, well, yeah, we're going to file probate, no problem, let's just get the ball. You cannot do that because there is no one that is legally authorized to sign on behalf of that estate. So the listing agreement is invalid. If you enter into a contract, it is invalid, and that can open up a lot of liabilities for you, of course. So you want to make sure if probate is needed, probate has to be opened, and it can take anywhere from a couple of weeks to a couple of months until the personal representative is appointed by the court, and then that PR can go ahead and sign on behalf of the estate. Another thing that we see a lot of times, which can be really tricky, is when probate is opened, a personal representative is appointed, the listing agreement is done properly, the contract is done properly, and now we get to closing, and the personal representative did not apply for a tax ID number for the estate and did not open a bank account in the name of the estate. The proceeds cannot be sent to the personal representative. The proceeds can only be sent to the estate. It's the estate of XYZ that is the owner of that property, and the personal representative is required to manage that. So if there is no bank account for the estate, then the best thing we can do is, since we can't wire into an account that doesn't exist, the best thing we can do is either issue a check to the estate, which of course the personal representative cannot cash. They can probably take it to the bank and open an account, or we can send it to the attorney that is handling the probate and have them hold it in trust. So if you're working with a probate scenario, probate has to be opened, obviously, but once a personal representative is assigned, they need to apply for a tax ID number for the estate because they're going to have to file a tax return, and they need to open a bank account for the estate, and then that bank account is supposed to be used to handle all of the assets and pay creditors and so forth. And a lot of people obviously don't know that. And if they're getting an inexpensive online probate attorney, they may not educate them on that as well. So as a real estate professional, this is your opportunity to educate your clients. If you have any questions about this, I'm not an attorney, but I'm a title agent, and I've done a lot of these. Feel free to send me a message, and if it's something I can't answer, I will, refer to an attorney. But as always, thank you so much for taking the time to watch this. If you are not subscribed to the email, go ahead and click on the link in the description and sign up so you get this in your email inbox every day, because on social media it can be hit and miss whether you see it or not. Thanks so much and have a wonderful day.